Good morning. The Senate Judiciary Committee will come to order. Thank you all for being here this morning. Our order of business is confirmation hearing regarding Judge Rachel Pickering to be considered for the Kansas Court of Appeals. I want to just take a few minutes for those in the committee meeting room and those following along online to share a few words about the confirmation hearing process. Clearly, the business before the committee today is the consideration of the appointment by Governor Laura Kelly of Rachel Pickering as a judge for the Kansas Court of Appeals to serve subject to retention elections as set forth in statute, succeeding the Honorable Anthony Powell. KSA 20-3020 provides that any vacancy on the Court of Appeals is filled by appointment by the governor with the consent of the Senate. It's one example of the checks and balances that we have between the branches of government, with the executive branch, the office of governor, making the appointment, and the legislative branch through the Senate holding confirmation hearing. To be qualified for appointment, the person shall have been regularly admitted to practice law in the state of Kansas and engaged in the active and continuous practice of law as a lawyer, judge, or of a court of record or any court in this state, full-time teacher of law in an accredited law school or any combination thereof for a period of at least 10 years prior to the date of appointment. Since KSA 20-3020 became effective in 2013, this appointment and consent procedure, I think this is the 10th time that this procedure has been used. This Senate committee for the last biennium and this year, this will be our 6th confirmation hearing. So thank you all for working hard on those and recognizing the importance and the precedence of this historic matter. We want to make sure that we are proceeding accordingly. Over the weekend, in advance of this hearing, there were some correspondence that was sent by myself, the chair, the vice chair, and we had reply letters from the governor's office as well as from the nominee herself. So I want to take just a moment to explain to the committee the correspondence that was shared for those who aren't familiar with what was in the letters and why they were brought forward. The correspondence started with a letter from the chair and vice chair of this committee to the nominee and copied the governor and the committee as well, raising a question about a case in the background of the nominee. It's one of our duties as the checks and balances procedure and the confirmation procedures to look into the legal background experience of our nominees that are brought before us. And that's what the letter to Judge Pickering, the intent was to raise the issue. And the issue was the case of Penn versus State. And the issue before the court in that 2012 case was the claim by Mr. Penn in that case that his counsel at the time, Ms. Pickering, was ineffective counsel for him on his appeal. In Penn versus State, the Court of Appeals went on to determine that it was the strategy pursued by Ms. Pickering was objectively unreasonable, and the decision of the Court of Appeals was that she, in that case, was ineffective assistance of counsel. That letter was sent, and we got, as a committee, a reply from the governor's office as well as from the nominee herself, explaining that the case was some 15 years ago. And since then, she has had an opportunity to serve in many different roles, including on the bench and in the Attorney General's office and in the Shawnee County District Attorney's office as well. So that was kind of the back and forth over the weekend about the correspondence that should be now in the committee members' files. And just thought that deserved a little bit of extra attention since many on the committee are not attorneys, and it's a lot of interpreting case law and decisions from the court. So with that, then, does that bring up any questions kind of procedurally about the letters from anyone on the committee for me or the revisers to explain? Not seeing any then. So we will start our questioning then. Before we do that, as we usually do, invite Ms. Pickering to make an opening statement or any remarks she may have prepared for today. And I don't want to be confusing to the public who's following along. If we call you Judge Pickering, it's because you do serve currently as a district court judge. So please welcome to committee, and please approach the podium and any opening remarks. We do have a limitation on time, so I'm going to ask Judge Pickering to please keep her remarks to 5 minutes. There will be an opportunity at the end to make a closing statement as well. And then we will go around as we usually do, alphabetically, and 5 minutes each for our members to ask questions. And with that then, Judge Pickering, the floor is yours.
Thank you. Good morning. Thank you, Madam Chair, Vice Chair, Ranking Member, and members of the committee. I greatly appreciate the time that you gave to me before today's hearing, as well as today's hearing today, to come and speak with you. My name is Judge Rachel Pickering, and I'm a Shawnee County District Court Judge. Before being appointed to the bench, I practiced law for 16 years. I was born in Galveston, Texas, the fifth of 10 children to Dr. Gilbert Corrigan and Esther Cabrera. Married for 48 years, my parents shared same values, including wanting to have a large family. They chose to settle in St. Louis with their 10 children, where my father worked as a forensic pathologist and served with the U.S. Medical Reserves. Together, my parents strove to teach us a strong sense of duty, family, and faith. To say that growing up in a family of 10 children forms who you are as an adult is quite an understatement. I idolized my older sister and 3 older brothers and cherished being the older sister to 5 younger siblings. Family is important to us. We were also raised to serve the community. I saw through my older brothers and sister serving and volunteering, and so at 5th grade, I started working at our parish's fish fries. I also worked throughout that grade school and high school. This certainly instilled in me at a young age the importance of service to the community and helping others. Naturally, when our son was older in Wamego, I was the assistant Cub Scout leader for our son's Cub Scout pack and volunteered at the church. We were also raised to respect the law, lawyers, and law enforcement. My mother's brother was in law enforcement, and our grandfather, William Corrigan, was a preeminent trial attorney. We were raised with stories of his achievements, including defending Sam Shepard in the infamous murder trial, which spawned the 1993 movie The Fugitive and the 1960s TV series. My 3 older brothers decided to choose the law. When it came time for college, I went to the local university, University of Missouri St. Louis, on scholarship and studied history. It was there that I met my husband, Jeff, another college student, and we were married in 1994. I, too, wanted to go to law school like my older brothers, but I had to wait. We were a young family just starting out, and we had to save money. So I went and got a paralegal certificate and worked at an intellectual property law firm. In 1997, K-State gave my husband a position at the university, and so we decided to move to Kansas. This move to Kansas was monumental in shaping our lives and raising our family. Coming to Kansas as an experienced paralegal, I was able to work at K-State University Research Foundation, which is now K-State Innovative Partners. So I was able to work alongside commercial startups through a coordinator position and see firsthand the importance of a client's intellectual property and the commercial development. These 2 experiences convinced me that law school was on its way. In 2000, I entered University of Missouri Law School, where I earned a certificate in e-commerce and intellectual property, started a law school student group in IP, and later spent my third year at KU and worked at Hovey Williams. It was with the birth of our son that we decided to move back to Manhattan, and I took a pause in practicing the law. After taking some time off, I chose to practice appellate law, which was perfect for a family with a young child. And in that time, we moved to Amigo, a small town of 4,400, which is ideal for raising a small child. At the appellate defender office, I was able to learn the appellate practice. I then moved on to being a public defender and was given the chance to work at Shawnee County District Attorney's Office as a trial attorney, and then with the Attorney General's Office as Assistant Solicitor General, now handling appeals, not from the defense side, but from the prosecution side. Through these experiences, I've argued 35 cases at the Kansas Supreme Court, and I enjoy being here in the historic old Supreme Court. Over 40 cases at the Court of Appeals. I've argued in 9 different Kansas towns. I have filed over 300 briefs, and I've coached 5 moot court teams and taught a class, created a class on oral argument. If confirmed, I'd be able to bring a district court judge's perspective to the appellate bench, a decade over of appellate practice, a breadth of experience, a balanced perspective, having both defense and prosecution, and lastly, a passion for oral argument, which is key for allowing the citizens of Kansas to see our courts at work. Thank you.
Thank you. And wanted to, before we proceed, welcome to committee. We have a senator sitting in for our District 13 member who has not yet been selected. We have Senator Virgil Peck sitting in on committee with us today and part of our committee. So thank you for joining us, Senator. With that, then, we will entertain questions for the appointee from the committee. We'll start in alphabetical order, and we will start then with Senator Baumgardner. And please keep our questioning to 5 minutes. Thank you.
Thank you, Madam Chair, and welcome to our committee.
Thank you.
So talk to us about your experience with sink cases. How many sink cases have you worked on, and what have you gleaned from that opportunity?
Okay. First, to begin with, the sink docket is probably the most important docket in the courthouse. You don't learn that till you do it. I've worked over 1,000 sink cases. I've handled over 20 bench trials. My rulings terminating parental rights, which are very serious, are written out and affirmed by the appellate court. From that time in the sink world, as it says, you learn so many different about the agencies, about how they work. But I want to tell you, Senator, the thing that I'm most proud of as a district court judge is the Shawnee County Sink Bar. The pandemic came down on a March 16th of 2020. We were supposed to have a sink docket. But as you know from sink cases, you have a grandparent, a parent, and a young child. And there was concern about people getting ill. And so we had to pause it and do telephone conferences. We didn't pause sync through the entire pandemic, and we're back doing telephone hearings on April 20th. So those kids who are running away, who had to be brought in, those kids were removed from homes because there's been a drug raid on a house, those kids are abused and neglected, their cases remained and were heard throughout. So we started with telephone hearings until one of the attorneys said, Judge, there's this thing called Zoom, and I'd like you to look at. And so we did Zoom hearings. We taught the parents and grandparents how to come in by their phones. So throughout this whole period with Sync, I've learned so many things. And in fact, can I just say one more thing, Senator? I nominated the Shawnee County Sync Bar for the KBA Service Award because of their endless dedication to their clients' cases in the community. As a judge, and I state this, my statement, a judge can only move a docket so far. You need the attorneys to support you, and that's what I had with these attorneys.
Okay. Moving forward with your experience with sink cases, share with us how it is. You know, I serve on the Child Welfare Oversight Committee, and we've struggled with kids and placements, and we continue to hear that the gals, the guardian ad litems, or even the appointed caseworkers don't really know the kids. So, in your role as a judge, how were you able to determine whether or not a, a recommendation was truly in the best interest of the child, that folks actually knew what was the best interest of the child?
When we had our sync cases, we had 4 attorneys, the district attorney, the guardian ad litem, and the parents' counsel. I made sure that in reviewing the reports from the agencies, that I would call specifically on that guardian ad litem to hear the recommendation, and I would ask, have you seen the child? When was the last time you've seen the child? So that was one way to determine the focus that the guardian ad litem was doing. In addition, the parents would say the guardian ad litem just came over and saw the child. So there were many ways to find out whether the children were being looked in by their attorney.
You have indicated somewhat in your opening presentation about the breadth and the depth of the experience that you have, legal experience, not only as an attorney, but as a sitting judge. So go through again that list of what is the breadth and what is the depth as far as areas that you have actually served in. And in this new position, what does that caseload look like? How does that match up in a Venn diagram? Are we going to see a lot of overlap with
Okay.
your experience
Well,
and what it will require?
okay. Breadth is before the bench, 16 years, and we get to start with intellectual property. So it's not just criminal. We start with a private civil law firm, boutique in Kansas City. So I've already learned that. So with intellectual property. In addition, I learned the trial experience both as a prosecutor and a defense and now presiding judge. So I've had to be that prosecutor putting that case forward to the jury. I've also had to be the defense counsel and worked to defend. And now as a judge, I'm presiding. So in the courtroom, I've done all 3 spots. So that is it. In addition, when that defendant is convicted, let's just walk through that. Actually, we could start with a search warrant. As a judge and as a prosecutor, I reviewed search warrants. And then the complaint comes forward. As a judge, prosecutor, defense, I've done the preliminary hearings. I've also done the plea hearings, the trials, and then move forward to the sentencing. When that case is appealed, I filed the notice of appeal as a defense attorney. I've responded to it as a prosecutor. And then as a prosecutor, I filed the appellee's brief. As a defense attorney, I filed the appellant's brief. So I basically am walking you through from the start of a search warrant all the way through a trial, an appeal, and luckily at the Attorney General's office, I was able to work even on federal habeas cases. So from the very beginning of that search warrant, all the way to trial, appellate, arguing at the Court of Appeals, petitioning the Supreme Court, and then that case being heard at the federal level is the breadth of my experience. So I think that's a nice way of explaining that.
I think I have time for one more question.
We're over time, but go ahead and conclude with your questioning. Go ahead.
So talk to us about the strategy. In the Senate, we refer to it as the peanut. So what was the strategy with the case where you chose, these are the arguments I'm going to make, and we're talking specifically about the Penn v. State?
Right. In Penn v. State, this is somebody who is charged with and convicted of rape by force of fear or incapacity to give consent. I reviewed the entire record, and I had the issue that the Court of Appeals found that I did not raise. I actually raised it in my initial brief. And so I raised that issue along with several other issues. I and the editor looked at that. And under appellate practice, you're supposed to give the best that you can. If you present weak issues, it dilutes the strength of your brief. Insufficiency of evidence, and I reviewed the record thoroughly, was not there. And so after going through the brief with my editor, we decided to leave it on the cutting room floor. So that issue was not in the final brief. The strategy is you bring the strongest issues forward. And if you dilute your brief with any issue, the Court of Appeals will start not paying attention to your briefs. They'll start telling you, you always bring this up. So that was a strategy's decision. But something more important, Senator, there was never a hearing on this matter. So the Court of Appeals never got to hear from me on why I did what I did. And they are dictated under Kansas law to give deference to strategy and why they did that.
Madam Chair, thank you.
Thank you.
Thank you. Next, any questions? Senator Bowers.
Thank you, Madam Chair, and welcome, Judge Pickering.
Thank you, Senator.
I don't have a line of questions, just a few things I wanted to note for you that I'm very impressed with your work with the Attorney General's office and then at the local level too. And particularly working on your social side with the youth, I think it's important that we work with the kids, that they understand how trials and what a judge does in your mock trials that you do for the kids. And I'm a big fan also of your Boy Scouts and Girl Scouts, so I'm glad to see that you follow through with that. And thank you very much for coming before us, and you're doing a fine job. Thank you.
I just want to tell you, Senator, it meant a lot to me when I was the truancy judge, because all those experiences of working with the Cub Scouts and those boys who were age 10 and age 8, age 9, I was able to talk to them as now a judge to get to school. So thank you.
Thank you again, and thank you, Madam Chair.
Thank you. Next, any questions from Senator Corson?
Thank you, Madam Chair, and welcome to committee, Judge. You touched on it a little bit in your answer to Senator Baumgartner's last question, but when reviewing an attorney's work, courts give deference to those attorneys regarding their choice of strategy. Can you explain to the committee why that is the case?
Right. The reason why they do that is they want to prevent distorting the effects. They don't want to do a Monday morning quarterbacking. And so that prevents that from happening. In addition, they are attempting to assume that the attorney had looked at it carefully. And so defendants usually have a hurdle that they have to overcome, that they presume that the attorney did the right thing. So they have to be open to the attorney's strategy who is reviewing that case. And that's why they give deference. They don't want to distort things from a 2020 hindsight.
Now, I understand that you were invited to sit with the Court of Appeals last February. Can you talk about what that experience was like, what you gleaned from that, and how that would maybe give you, hopefully, kind of like a running start if you are indeed confirmed?
Indeed, it was a running start. It gives me that. So that was quite an honor to be invited to sit with the Court of Appeals. It was in February. I sat with them on February 7th via Zoom, and it showed me all the work that the Court of Appeals judges do in preparation for that docket. So I was a learning lesson of eyes wide open in terms of this is the work that is required. I also learned the importance of getting those opinions timely filed, which I made sure I did. In addition, there were 15 cases that I and 2 other judges reviewed, and of those, 9 were criminal cases. That lends to the point that I've told other senators, 70%, more than that, of the Court of Appeals cases are criminal. And so when I sat there in February, I saw firsthand, look, 9 are criminal of the 15, and 1 was a child needed care case. So I was already up to speed. I was able to work on a worker compensation case and a protection from stalk and abuse case, which I was able to cite to the legislature for the statute and in view of the protection from stalking. In addition, it showed me how prepared I am to come sit on the Court of Appeals because I worked on 5 opinions, and I also was engaged with the oral arguments themselves. So it showed me all that experience that we talked about, Senator, came into play at that February 7th docket.
And can you talk about your experience as a district judge? Looking back, you've had a diverse experience. You've done criminal felony stuff. You've done child in need of care stuff. What would you say is is sort of your proudest accomplishment from your time on the district court bench?
My proudest accomplishment, and it leans to Senator Baumgartner's question, is the sink cases stayed open during the pandemic. The temporary custody hearings that you have to hear within 48 hours were heard. We had them in the courtroom. Everyone was masked up. We had those cases. So nothing was neglected. So the safety of the children. In addition, those truancy cases that I referenced, those cases were heard. So especially while kids are dealing with Zoom and schools getting closed, we wanted to make sure we took care of them. So that was my proudest moment. In addition, if I could say one thing, my second trial as a presiding judge was a first-degree murder trial, a 5-day first-degree murder trial. And there I am. But because of the experience I had that I talked to you earlier about, that I've gone from a search warrant through a trial, through appeals, I was very comfortable as the presiding judge, issuing the jury instructions, making the rulings from the bench, hearing the voir dire. So I think I was most proud of, wow. And I talked to the court reporter later, say, did we really do a first-degree murder trial as my second trial? She's like, yep. And so that to me is just, you roll up your sleeves and you jump right in.
And last question, we've talked about the depth and breadth of your experience as a practitioner. But one of the things I really enjoyed in your resume is your experience as a professor, as an adjunct professor, and as a mock trial coach and judge. Can you talk about some of what you're teaching at Washburn, what that experience has been like, both in the classroom and with the mock trial students?
Right. So for 1 week, I have a fundamentals of oral argument class. So what happened was I coached teams at Washburn from 2014 through 2019. There was a lull, and I had all this energy, and teachers will tell you, we have all this energy, we want to go teach. There was this lull, and so I went to Professor Master Simone as Associate Dean. I said, can I create a class? I want to do it for 1 week, literally from a Sunday through a Saturday, where I throw the case in front of the students, and it's always a pending U.S. Supreme Court case. So the students love it because it's not made up. They get to track what's happened in the U.S. Supreme Court because we take one of their cases. And we teach them and it's a brutal, hard week, but we teach them the drills of oral argument. And so starting on Thursday, I will bring in practitioners to come and judge. Sean Minahan is one of them. Heather Cessna is one of them. They've come in and they've helped me judge. So we bring in practitioners from the Attorney General's office, from the Appellate Defender office, from the District Attorney's office, live practitioners to come and judge the students. And so not only are they learning the skill set, they're meeting members of the community. And then they hate me on Tuesday, Wednesday, Thursday, Friday, and I tease them. But by Saturday, when they present their final presentation, they really enjoy the class. So thank you for asking. It's a thrill to teach it.
Well, thank you for being here. I don't have any more questions, Madam Chair. Thank you.
Thank you. That's a good thing because your time's up. So then we will hear from Senator Gossage, who is joining us online via WebEx. Go ahead, Senator.
Thank you very much, Madam Chair. I appreciate, I want to say, first of all, Senator Baumgartner's question about the sink cases, as she and I have served on the Child Welfare Committee together, and some of that testimony was harrowing. So you've already answered my questions regarding those cases, but I would like to research these issues further, but this is not the time. I just want to ask a couple of quick questions. In your statement regarding the Penn case, you said, and I quote, I care deeply about appellate practice, and I wanted to make sure that others can learn from my experience, end quote. Could you tell us what you mean by that, and what did you learn?
Absolutely. So appellate practice can be harsh. And it helps if you can lead the way to others to help them. And so what I did is I started teaching a best practices CLE. In November 2013, so this is a year after Penn came out, I taught a CLE, continuing legal ed, to down in Wichita on appellate hurdles. So these are ways to which you're not allowed to get your brief filed or considered all the things that are preventing you from having your case heard. And so it was a practice, best practices of this is what to do. Learn from me because I've gone through it and I'm trying to show you the way. So you have to be humble when you teach that CLE because you have to show them these are things that have tripped me up. I don't want the same to happen to you. In addition, in February of 2015, I and two other appellate practitioners who are both now serving on the Court of Appeals gave a joint appellate practices CLE here in Topeka. So we have appellate hurdles shortened version for practitioners doing defense. I gave that presentation 15 minutes. We then brought in a prosecutor who dealt with appeals saying these are her challenges that she's had and learned from them. Finally, we brought in a civil practitioner to come in for 15 minutes to give these the issues that are preventing her from doing her best or things that can be a hurdle and learn from her. And so we wanted to get that out to appellate practitioners of these are things that are coming your way, learn from them. I'm a big believer of teaching as I go, and you have to be humble because you have to show this is something that I've made a mistake on, but you could, so I want everybody to do a good job.
So when you're talking to your students, do you tell them what you would have done differently and how the outcome of the trial might have changed?
Well, that's interesting. You asked that, Senator. So when somebody heard I was teaching this class, they said, "Are you going to show clips of me from the Supreme Court argument?" I said, "Nope, I show only mine." For example, I'll show a clip of a rebuttal that I've done years ago, and it's way too long. The rebuttal should have been 2 minutes. And so I play it for the students on a video, and I give them the exercise. All right, raise your hand when you think I should have sat down. And they enjoy it. And I show them, look, should I have sat down there? They're like, yep. I show them from my work, here's what not to do. And so it gets that to humility part, but they enjoy it. And so it's also making sure that I can pass on the wisdom that I have, all those oral arguments that I've done to the students.
And if I may, Madam Chair, I'm sorry, Judge Pickering, but what I didn't hear was how the outcome of the trial, the Penn trial in particular, would have changed had those things not fallen on the cutting floor that you mentioned earlier.
Oh, if I had raised it, you would have to assume that it would have won. When it was filed and briefed, it was in front of a different panel. And so the panel of Court of Appeals said it would have been victorious. A different panel may have deferred. And so if it had achieved itself, then that issue wouldn't have come forward and he would have been able to raise that issue.
Thank you. And thank you, Madam Chair.
Thank you.
Thank you. Next, any questions from Senator Haley?
Madam Chair, thank you. And thank you really for being here today. Welcome to the committee and for enduring this process and for going through this, taking time to meet with many of us prior to. It's been a pleasure to get an opportunity to meet you, Judge Pickering, and to review some of what I believe is a stellar record. The longer we go down this list in the alphabet, the more and more the questions that one may have had are being answered. And perhaps I should, more than anything else, try to reserve the balance of my time to potentially rehabilitate you for what may be the end of the alphabet, because there's still some interesting members of the committee to go. But I've been through more of these confirmation hearings than anybody on this committee, and you get a feel really for how a sense for where good candidates are and how they emerge. You're doing exceptionally well, ma'am, let me say, during the course of this. And the breadth and the scope of your experience is pretty unique. This committee and others have put law clerks who didn't have, judicial or bench experience or trial court experience, have moved them through this process. As a lawyer, a judge, court of record, it's just, it's impressive to see what you're doing with this tremendous track record. So if they're hanging their hat on a ding from, a decade and a half ago, which since you've had numerous numerous cases and matters, then I think that you'll continue to move through this process well. You certainly should. I guess if I had anything, it would be, are there any other strengths, anything left to ask? Because you've gone through your experience enough, and you've gone through your perspectives of being, on the bench in the justice in the district court. So, I mean, you've gone through some of the extracurricular activities that you've done, but are there any other strengths that you would bring, you think, to the perspective of the bench on a
Sure.
broader scale?
In addition to that breadth and depth of understanding the law, I bring a passion for oral argument, which is very important because the Court of Appeals travels across the state. So I've seen them when they were here at Washburn Law, KU Law, Kansas State University. I've been down to Pittsburgh, Salina, Concordia, Kansas City, Kansas, when the Supreme Court came. So you have to have a passion for oral argument, which helps you as a sitting judge to be able to be there, to be ready for those attorneys in terms of preparation and asking them questions. In addition, a strength that I bring is I write very clearly. I'm not here to impress you with how many big words I know, because I really don't know those big words. I write very clearly. In addition, as a district court judge, I could tell you how much judges go through the opinions that are issued, and they're looking for direction. So not only do I write clearly, but I've seen how important it is to write and educate the district court judges on the rulings. So muddying up the waters does not help. Clarity is very important. It's also important for attorneys when they lose a case and they have to explain to their client, why did this lose? Why did this happen? A clear opinion shows that and breaks it down for them. So clarity is, to me, a strength that I bring. I enjoy writing. I love the editing process. And so a passion for oral argument and a good writing skill set.
Well, that's excellent. Somebody who got a C in legal writing in law school, I admire those who have gone and done exceptionally better in that. Again, you're, I believe, an exceptional candidate. You've done exceptionally well during this process, and I hope that we will move expediently on towards your confirmation. And thank you again for being here.
Thank you, Senator.
Good luck toward the end of the alphabet as we move forward.
Well, we're on H, so I guess the next letter.
Thank you, Madam Chair.
Thank you. Next, we'll hear questions, if any, from Senator Olson.
Well, been here 19 years, but I'm the newest guy on the committee. This is my first one. To me, I appreciate you coming by and talking with me. You spent quite a bit of time telling me about your background, learning more about you, looking at your packet. It looks like you've been committed for a long time to the law and looking at all aspects, from the public defender someone that worked for the defendant to, someone that worked in Attorney General's office and the court system. To me, it looks like a pretty impressive resume and
Thank you, Senator.
a lot of commitment to get to this point. So that's my comments. Thank you.
Thank you, Senator.
Thank you, Senator. Next, Senator Peck.
Thank you, Madam Chairman. I'm not in the legal field, not an attorney, so I'm going to ask a question from a outside, if you will. You sort of brought up some things in your response to Senator Haley that go down a little bit the line that I was going to look at. I'm going to use the phrase case law. That may or may not be the proper legal term, but my understanding of case law is where a judge or a court has issued a ruling or an opinion or an interpretation of law. Sometimes when I look at those opinions, I don't see those as following statute or the intent of the legislature, but frequently courts and attorneys and judges will cite case law. Understanding that court personnel changes over time, understanding that public opinion can change over time as it relates to certain topics or issues. As a judge, what would be your philosophy as it relates to ruling or handing down a ruling that is different from case law, even if that ruling or opinion came from the Supreme Court or an opinion that you would expect the Supreme Court? So I guess to cut it to just one question, do you have a willingness, do you feel you have a willingness, and I realize every case is different, to muddy up the waters, if you will, with a ruling that is different from case law or what you perceive from the Supreme Court?
No, clarity is very important, and I start with the statute first. I start with the U.S. Constitution and go through the statute. So I follow the law, and that's always been my mantra through all this is you follow the law. You don't go left, you don't go right. And so that's the clarity that is very important. And so that would be my philosophy. It's always been my philosophy as a judge to be unbiased, impartial, and to follow the law as the statute writes. Case law, and that's a great question, Senator Peck, about how case law can go one way or the other. And it's important. In fact, one of the opinions that I wrote about a person's probation violation, I separated the case law and said, this is where the defendant wins. And under these cases, they lose. And I separated it and identified the two different thoughts. And I explained, this is why the defendant will lose. His case mirrors and follows other cases that have said about his case. So I am clear in that and make sure that you don't muddy the waters, because as a district court judge sitting now, I want as much clarity as possible from the appellate courts. So thank you, Senator.
I guess I'm someone who prefers muddying the waters at times, if that's the belief that that's the proper interpretation of statute versus case law.
Right.
I'm going to move on from that a little bit. We have in front of us in our packet a letter from the chair and then a response letter from the governor's office as it relates to Penn v. State. And in the letter from the chief of staff of the governor, it says that their office was aware of the issue that was raised in Penn v. State. So you apparently had made the governor's office aware, but the governor's office chose not initially to pass that information on to this committee. Do you have any knowledge of why that would be withheld, or were you consulted about that being withheld? Because we're the ones that are tasked with making a determination as to who should be on the appellate
Sure,
court.
absolutely. No, I don't have the background information. I could tell you in the questionnaire, when it talked about professional misconduct, I made sure I addressed that. Penn v. State has since been overturned, so it's no longer good law. And that's why I cited State v. Vargas, that this case that alleged that I didn't do the right thing has since been disagreed with by the Kansas Supreme Court. So it's not even a valid case. In addition, this did not involve a disciplinary complaint. It was not relating to prosecutorial misconduct. So on my end, I wanted to answer that questionnaire the way it was supposed to be. In addition, I'm here to answer your question, Senator.
Well, and Judge Pickering, I appreciate that. My concern was that it appears to me that it was withheld information that not vital, but would have been beneficial for the committee to have. And it is, again, not on your back, but it appears that it could have been a little more forthcoming than it was.
Okay.
And I realize, Madam Chairman, my time is up, so I will yield the floor back to you. Thank you.
Thank you, Senator.
Thank you, Senator. If you had another question, we had allowed that earlier. If you have one more question before you conclude. Thank you. Then Senator Wilborn.
Thank you, Madam Chair, and Your Honor, thank you for being here and taking time to have a nice, what I consider discussion and visit in our office. Your background, obviously, has been stated before, is very broad, has a lot of depth. But I do want to go back to one thing, heaven forbid, the Penn State. I want to know who asked the question in the vetting committee on behalf of the governor. Did they already know about the Penn versus state, or did you divulge that to them?
Oh, I don't remember, but I do know I talked about it. I did talk about it. I don't know who brought it up, but I want to talk about that case.
Yeah.
I mean, when they brought it up, so I
My
don't
question
remember.
wasn't to criticize.
Right.
It was to
Yeah, I don't.
explain the process.
Yeah, I don't remember.
Like Senator Haley said earlier, all the questions have been asked around the table, but so I have no other further questions, and good luck to you.
Thank you very much, Senator. I do appreciate that. I do appreciate people pointing out that was from a brief from 15 years ago, and it has since, it's no longer sound law. And so I appreciate you answering my question, Senator.
Thank you, Senator, and thank you, Judge. Now it's my turn.
It is.
To follow up on Senator Wilborn's questions and your comments that it's no longer good law, and we've been talking about clarity, could you clarify, did, when Penn versus State, the Court of Appeals did find that you were ineffective assistance of counsel, and then there was a later case, State versus Vargas. Correct me if I'm wrong, State versus Vargas was talking about kind of the merger doctrine, not looking at whether you were ineffective assistance of counsel or not. Is that correct?
Yes and no. And can I explain?
Please.
There's two prongs to ineffective assistance of counsel. One is, was their actions reasonable? Because there was never a hearing on this, I could explain my trial strategy, and they would have said, oh, it was reasonable. She was following the best practices. But there's a second prong. Would that have prejudiced the defendant? Because the way this Penn court looked at it, they took two guilty verdicts. One, they said insufficient evidence, and the second one, they never merged the two together. If they had followed what Vargas said they should have done, that defendant would have stayed convicted. So that's the second prong of ineffective assistance of counsel is, did this actions prejudice, did it make an effect? And if they had merged the two together, it wouldn't have made a difference. And that's what the district court judge ruled on when he first looked at this, probably in 2011. He said, wait a minute, it doesn't matter if this issue is raised or not. He was also convicted for an alternate crime, the same crime. So it wouldn't have mattered if she raised this issue or not. He stands convicted. Unfortunately, the Court of Appeals didn't merge the two, and that's what Vargas says, is they put into question that they said they should have been merged together. So that gets the second prong of that answer. So I would not have prejudiced the defendant, and therefore there wouldn't have been a IAC claim.
Thank you. In your work as appellate counsel in the Penn matter, when you were deciding your strategy, and I think it's important for Kansans to learn kind of the thinking process of those who could be serving on our Court of Appeals. At the time you were considering your strategy, didn't you know that the case at the time, there was no conviction for the force or fear counts, and it was only the incapacity to consent counts? You're
No.
shaking your head. That's not
No.
right.
I never saw it the way the court did. The district court did dismiss it, but a jury had convicted him of this crime. And so the court should have, I thought the court would remand it. And they say that in Vargas under State v. Sanchez, a 2006 case. So if you looked at the case law at the time, you would have seen that the conviction should have stood. And the reason why I bring that up is because it shows the analysis involved of would this stood or not. And I'm trying to find it real quick. Here it is. when they talk about, in Vargas, they're skeptical of the Penn court's offhanded comment about merging. They mention State v. Sanchez from 2006. Even if a conviction for one underlying felony must be reversed, that conviction would still be valid. And so if you had looked at that case, a Kansas Supreme Court case from 2006, you would not have thought that that second conviction guilty verdict would be simply dismissed.
But you knew that it was dismissed at the time. And I'm just trying to let Kansans know that, and I want to ask you, the Court of Appeals found their standard was her decision not to challenge the sufficiency of the evidence objectively unreasonable? Objectively unreasonable. Not was it a mere strategy decision, but even so, would a reasonable counsel have brought the argument? And the court, in its decision finding ineffective assistance of counsel, found that the strategy you ultimately employed was objectively unreasonable. So, do you agree with the Court of Appeals finding in that Penn versus State case?
No, there was no hearing to explain my trial strategy. They made a ruling with nothing, no factual findings whatsoever. If they had sat down and I had been able to testify at district court, I would have been able to show my drafts saying, here it is, here's the issue, and here's the final draft. And take a look at how I read it. And it wasn't strong. And I would be able to show that there was evidence to support the conviction. So that's the analysis that you do. And not only did I not consider it, I wrote it out and put the issue in the full brief. So I would be able to present that for the district court in terms of reasonableness of she did review it. And so I would disagree. I think it's very important to give deference to attorneys, but also to hear from them before you make a ruling on whether it was objectively reasonable or not. So,
is that the primary role of the court, to hear from attorneys or to look at the facts and the law?
Correct. Well, the Court of Appeals made it without looking at trial strategy because there is case law that says failure to raise an issue is not de facto ineffective assistance of counsel. You can't just say just because a person failed to raise an issue, they're ineffective. Because
the court
they have to have trial strategy. They have to look at that, and that wasn't done here.
Getting to the question of, did you disclose the finding of ineffective assistance of counsel? Did you disclose that to any senator that you talked to before the hearing today?
Not that I remember.
I think you and I had a conversation that I asked, is there anything you regret in your legal experience? And you didn't think of anything. So was this one that you regret or you don't?
Well, looking back, there's lots of regrets that one has in their legal analysis. And so there's always that. But that case, because it's been overturned by Vargas, I didn't see it that way. And I've been very open with all the senators wanting to ask all their questions.
And did anyone on the nominating commission or committee ask you about the finding?
I know they asked me a lot of questions about my work on both the appellate bench, and they've asked me questions about my expertise, and they've asked about the range of issues that attorneys go through. But I don't know if they asked about it specifically.
Did you disclose to it even if it wasn't? Did you disclose it even if it wasn't asked?
I'd have to go back and look at the nomination form. I know I've talked to people about it, because I've said there's this issue out there. It's since been reversed by the Kansas Supreme Court.
In your confirmation packet provided to senators, there was a question, any additional information favorable or unfavorable, which you feel should be considered. And you didn't think that this was a finding that was unfavorable?
Looking back, I could see where that was, but I was focused more on professional misconduct. I was focused more on that. In addition, because Penn versus State is no longer good law, I wasn't even thinking that way. I've always been upfront with my record. I've told people, come over to the courthouse and see me preside on the bench. There wasn't an effort to hide this at all.
I think the process of confirmation is very important, and the Senate kind of had to discover this issue without it being disclosed otherwise in the process, either by the nominee or by the governor's office. And it's important that we do have full vetting of our nominees. And so I for one, am glad that the Senate was able to discover this case and you were able to comment on it. We might have a little bit different interpretation of how Vargas impacts the case. However, that's what attorneys do, right? So,
Right. Well, that's why I sent my response a page that says negative treatment of Penn v. State, disagreed with by State v. Vargas. It's that outcome that Vargas reached. And so that's why. But I think there's something really important, and I think Senator Gossage really mentioned it, which is the learning lesson that you learn from all this. When you're going through this process and you try your best to be an appellate attorney, trial attorney, prosecutor, you want to learn from these. And so from this, I've kept going in terms of establishing best practices. And I actually tell it to my establishing best practices and serving the community and working even harder. So I do enjoy appellate practice very much, and I want others to enjoy it as much as I do.
I'm going to ask you another question about your appellate work because we're looking at qualifications in this committee. Your letter over the weekend said about the insufficiency of the evidence argument in the Penn case that as important, the issue was not strong in this particular case. And the likelihood of success on this issue was low. But when the court was considering the insufficiency of the evidence, it found it was objectively unreasonable that the argument wasn't brought forward. So, and I understand that on that particular claim, I would say Vargas didn't really address the insufficiency of evidence on that particular claim. But I appreciate that over the weekend, and I suppose yesterday on the holiday, you took the opportunity to send a letter to the committee and appreciate the explanation. And this is a political appointment. It's part of the process, the branches of government looking at this. And you did have some part of your background. You've been involved in political campaigns, both for candidates of both parties. And I think it's important for the public who doesn't necessarily see your confirmation packet to have that information as well. One of them was that a fundraising event for a gubernatorial candidate, and then that followed a year later with an appointment to the district court, and then the appointment here to the Court of Appeals. So again, it's important in our vetting process. I think the Senate plays a very important role in looking at our Court of Appeals and the different branches of government. So with that,
can I just add that I've worked on 3 Republican campaigns. So it's very important that I worked with Attorney General Schmidt, and so I see where your point is, but there needs to be known that, like every Kansan, you support the candidate that aligns with you, or sometimes you just like the person. And so I've worked with on 3 different Republican campaigns. I think that needs to be noted.
Right, and my comment was you both parties you
Yes.
had worked for, as
Yes.
well as Governor Kelly's campaign as well. So thank you for further clarifying that I was talking about parties, candidates from both parties.
Absolutely.
Of course. And then with that, we are over time for our committee, but I do want to offer you the opportunity to make a closing statement and also to introduce anyone in the audience with you that you brought with you today, family or otherwise. Committee, since we are over time, we will probably have to do our deliberations tomorrow about any recommendation. We will either recommend favorably, not favorably, or no recommendation at all. But go ahead, Judge,
Okay.
with about 3 minutes
Thank
for
you.
your closing
Okay.
statement.
I
Thank
won't-
you.
I won't need 3 minutes. This entire process has been quite an honor. I've enjoyed meeting all these senators. They've been very gracious in meeting with me and answering questions. My experience as a district court judge, an appellate attorney with the Attorney General's office as Assistant Solicitor General, and my defense work and prosecution work indeed permit me to start with a not as big as a learning curve that others have in terms of a court appeals judge. As an appellate judge, I would continue to do what I do on the bench, which is to follow the law. I would set aside all personal and biases, political biases, opinions, and decide the cases in front of me impartially. I'd follow the U.S. and state constitution, decide cases according to the law written to you as legislators. The principle of separations of power is indeed very important, and I would respect the boundaries of our three-branch government. So I very much thank you for holding your hearing. Senator Warren, I thank you for giving me the heads up about Penn because you gave me a chance to respond and you were doing your work in due diligence. And it's something that I appreciate being able to answer here today. So with that, I want to thank you for holding this hearing and I appreciate your questions. Thank you.
Thank you, Judge, for appearing in committee today and for those following along online and in the committee meeting room. And committee, if there are no other questions, we will not close the hearing because we need to have our deliberations and a motion come out of committee. But for today, we will adjourn our meeting, if I have said that right, for the revisers. So they indicate I have. So with that,